Good evening.
As far as I understand it, this is your meeting, so we're gathered here and live, so.
Okay. I didn't know if you were ready to start, but I am, so let's go. Thank you, members of the board and members of the public and council and everyone for attending this evening. My name is Art Krieger. I'm senior counsel at Anderson & Krieger in Boston. I'm the hearing officer for this hearing. I now open this public hearing by the Gloucester Board of Health on the application by Eastern Waste Services, LLC, for site assignment for a solid waste facility at 24 Condolin Road. Eastern seeks to construct a new solid waste management facility to handle and transfer up to 270 tons per day of construction and demolition waste, 6 days per week, for a maximum C&D acceptance rate of 84,240 tons per year. It also seeks to construct a new building of approximately 11,800 square feet for that facility. I'm going to take a few minutes this evening to explain the hearing and its procedures. We are not going to get as deep into the hearing as we ordinarily would, because this hearing is a hybrid, in person and on Zoom. And while I will attend all the upcoming sessions in person, I could not be there tonight. And because I am on Zoom, we're going to abbreviate the hearing, because it would be much more difficult to deal with witnesses and testimony and all the trappings of a hearing from here on Zoom. We may address some administrative and procedural matters to get them out of the way, but we won't get into actual testimony. Let me just pause there. Can everyone hear me?
Yes, we hear you well, Art.
Okay. Let me start by explaining the site assignment process for the board and for members of the public and anyone else who needs to learn a little bit more about it. Under General Laws, Chapter 111, Sections 150A and 150A and a half, and DEP's solid waste regulations at 310 CMR, that's Code of Mass Regulations, 16.00 and the following sections. Those are the governing, those set out the governing law for this hearing. The site assignment criteria for this board are found under 310 CMR 16.40. There are 7 criteria for waste handling facilities in general. That's 16.40 paren 3 paren D as in David, and 12 other criteria for all solid waste facilities. That's 16.40 paren 4. I'm giving those citations so that people can look them up if they choose. This is a 2-step process. DEP has issued a site suitability report finding that this site is suitable for site assignment for this facility under its siting criteria. That was step 1. And the board had to wait for this hearing for DEP to do that. But once DEP did, the board is under a very tight deadline to start the hearing, which we're doing tonight, to complete the hearing and for the board to deliberate and reach a decision. The board must now decide as step 2 of the process whether to grant site assignment for the facility under the same DEP criteria. But DEP's findings about those criteria and its conclusion that the site is suitable are not binding on the board. Let me address the legal standard for the board's decision so that people understand what the board needs to find. Under DEP's regulations, the board, quote, shall determine that a site is suitable for assignment as a site for, let me stop the quote because I have to put in some dots and brackets. But as a site for an expanded solid waste facility, unless it makes a finding supported by the record of the hearing that the siting thereof would constitute a danger to the public health, safety, or the environment based on the siting criteria under 310 CMR 1640, the ones I mentioned a moment ago. And that's 1620 parenthesis 10 paren K point 2. That standard for the board's decision bears emphasizing. The board shall grant the site assignment unless it finds that the project at this location would constitute a danger to health, safety, or the environment. The board is not in this hearing reviewing final construction plans or detailed operational plans for the facility, although those inevitably come up. Under the regulations, all applications shall be evaluated with the presumption that the proposed facility shall be designed and constructed to meet all relevant state and federal requirements. The review of an application shall not consider detailed facility designs or operations except in certain circumstances that I don't believe will apply here. So the board ordinarily stays out of design issues and stays out of detailed operations issues, but clearly some operations issues, like where the truck's going to go, are fair game. So I'll have to make a judgment about whether we're going too far in that direction or not. That'll be one of the judgments I need to make. Those two things that I just read are 1640 paren 1 paren C 1 and 2. My role as hearing officer is this. I was selected and hired by the board, but I'm paid by Eastern. That's the statutory scheme. That's the way it always works. Is the applicant pays for me, but the board has to select the hearing officer, and they've selected me in this case. I am required under the regulations to be unbiased, and I am in fact unbiased. I don't know the parties. I have no stake in the outcome. My job is to define the issues, receive and consider relevant and reliable evidence, and exclude irrelevant evidence, ensure an orderly presentation of the evidence and issues, and aid the board in reaching a decision based on the evidence presented at the hearing. However, even though this regulation refers to my aiding the board in reaching a decision, that means only in the sense of running the hearing and compiling a coherent record for the board to use to decide the matter. I will not decide whether to grant Eastern's application or even recommend a decision to the board. The decision will be made by the board with the advice of its counsel. My job is to simply shape the record and make sure that it's intelligible for the board and gets to the board soon enough for the board to meet the deadlines to decide the matter. On April 28, I issued a pre-hearing order after consultation with counsel regarding the hearing and the deadlines for various submissions by the parties. I'll get into that a little bit more later. That order is available, I believe, from the Gloucester Health Department and may also be on the city's website at this point. I think everything relating to this hearing is going to be posted on the website since it is all public information. Let me just identify the parties and counsel, the lineup that we have so far. The board is represented by Peter Durning and Peter Viteri of Verrill Law. I see.
Thank you, Art. Yep.
Durning. The parties are obviously Eastern, represented by Joel Favazza of Seaside Legal Solutions. I have only 6 screens on my computer. I don't know if Mr. Favazza is on. I assume he's on or there. Anyone?
Art, I do not see Attorney Favazza on the line or in the room.
I can't hear that.
I do not. He is not online or in the room, as far as I can tell.
Okay. I know he was expecting to be there. Any indication that he's in the waiting room of the Zoom call or otherwise having trouble that you know of?
I can see all attendees and all panelists, and they've signed in by name. And so unless he is not, there's nothing that identifies Seaside Legal or Joel Favazza as either an attendee or a panelist.
All right. And Dominique, I assume that's you talking? I can't see who's talking.
Yes, that's me. That's me speaking.
All right. Would you call him while I continue on with my comments? It doesn't seem appropriate to proceed without him if we can help it. Do you have his cell?
I can call him. Thank you.
Okay. I have his cell if you need it. In any event, Mr. Favazza will be here, and he will be representing Eastern. The Manchester by the Sea Board of Health is entitled to be a party as an abutting Board of Health. Sorry about that. So the Manchester by the Sea Board of Health is a party represented not by council at this stage, but by Public Health Director Wendy Hansberry.
Wendy is on the line as an attendee.
Good. Okay. The following have petitioned to intervene in this hearing. The regulations allow abutters, 10 citizen groups, and others to petition to intervene. And the following have done so. One is the City of Gloucester itself, represented by General Counsel Suzanne Egan. One is a 10-citizen group represented by attorney Mark Nestor. There's a 10-citizen group which has designated Kylie Davis as its authorized representative, not counsel, but sort of the lead citizen of those 10. Another 10-citizen group with Judy Rose as its authorized representative. Mr. Vito Ferrara as an abutter. The Gloucester EDIC, the Economic Development and Industrial Corporation, represented in its petition by its chair, Thomas Balfe. And those are the 6 that I have. Ms. Hurley, any others that you know of who have asked to intervene or participate?
There are 6. I didn't have Mr. Vito as an abutter. I had him as an intervener.
Well, he's trying to intervene on the basis of his being an abutter. I think he said he lives in the industrial park. I just skimmed his papers because they came in late in the day. In any event, any objections to any of those requests to intervene?
I didn't hear that question, Art. I'm sorry.
Yeah, no, I was getting a strange message about translation. Any objections to any of those requests to intervene are due by Friday the 9th at 5 o'clock. So roughly 48 hours. I will rule on those, on any objections and on the petitions as quickly as I can, because under my pre-hearing order, the interveners, if anyone is allowed to intervene, their pre-filed direct testimony of experts is due Monday the 12th at noon, so that we have their testimony in hand before Monday evening's hearing. Other Gloucester residents have submitted comments on Eastern's application, and Ms. Hurley, as the Director of Public Health, is maintaining a log of those comments. I'll come back to those comments in a minute. All Gloucester residents and businesses will have an opportunity to express their views on this application at some point during the hearing. I may limit the length of comments, and I will try to limit any repetitive comments, but everyone will have a chance to speak their mind at some point. I don't know exactly when that will come because I don't know how long the parties' cases will take. The director of cross-examination, I don't know when it will make sense. I'm thinking sometime in the middle of the hearing. So if people want to say their piece and then not attend the subsequent sessions, they're free to do that. But I want to get into the actual testimony before taking public comment. The schedule is as follows. Eastern is hosting a site visit on Monday the 12th at 3 o'clock, 3 to 4, I believe. Everyone is welcome to attend. It will be an informational session enabling people to view the site and understand the proposed facility in context. However, there will be no substantive discussion of the issues in this hearing, and nothing that is said at that site visit will be evidence. The hearing will continue in the Kairos, if I'm pronouncing it correctly, auditorium, Monday, May 12, and Thursday, May 15. If we need more sessions, we will schedule them as we go. Each hearing will run from 7 p.m. to 10 p.m. We all have work and family obligations, but I ask that everyone be as prompt as you can. I intend to start as close to 7 o'clock as possible. The idea, of course, is to have the fewest number of hearing nights for the benefit of the board and for the sake of finishing the hearing and letting the board start its deliberations as soon as possible. So I'd like to be as efficient as we can on the nights we have scheduled. Under the DEP regulations, the board must issue its decision by, I think the date is June 21. Council can correct me if I miscalculated that, but it's 45 days. And I believe that's June 21. Mm-hmm. Some of the procedures and logistics for this hearing will be as follows, and this will make a lot more sense when I'm there in person, and we have actual physical exhibits and people testifying. I see now that Joel Fabaza is signed in. Joel, can you hear me?
I can, thank you.
Okay, and you missed some of my opening comments, right? You just logged in?
Yeah, I'm here.
Okay. I will just say that I gave counsel, Mr. Fabaza and Mr. Durning, a copy of my draft opening comments. So none of this what I'm saying now, although it's slightly revised, will be a surprise to anyone. Joel, if you want to see the actual final comments as I'm reading them, since you didn't hear some of them, you're free to do that. You can let me know.
Yeah, no, I understood what the comments are going to be. Thank you.
Okay. All right. I will keep a list, or Ms. Hurley and I will keep a list of all official filings with the board, motions, oppositions, any rulings I make on evidence. And I will keep a list, or she will, or we will, of all documents that I admit as exhibits. And those lists, again, will be available at the board office, and I hope to have updated lists each time at the hearing. Council, when we reach the expert witnesses, I may proceed issue by issue. Traffic one night, groundwater one night, whatever. Having all parties address a given issue so that all the testimony on a particular issue is in one place for the board, so they hear it all consecutively instead of interwoven with a bunch of other issues. I will make that call as we go, but I'll consult you about that as well. Witnesses must attend the hearing in person. Nobody's going to be allowed to testify on Zoom. Anyone intending to give public comment rather than sworn testimony may be on Zoom, but witnesses have to show up. I usually try and address where the microphones are, cable TV not being in the room. I'm not going to try to do that tonight, other than to say this hearing is being recorded. Anyone may hire a stenographer to transcribe the hearing at their own expense. Any resident, any party is free to do that. The record on which the board will base its decision will consist of the oral testimony that I admit and the written exhibits that I admit. Public comments that are not under oath and subject to cross-examination may provide useful information, may provide residents' perspective on things, but they will not be part of the record, and the board will not be allowed to base its decision on comments that are not sworn and not subject to cross-examination. My pre-hearing order required parties to pre-file the direct examination of expert witnesses, I mentioned this earlier, and their proposed exhibits to enable the other parties to prepare for that testimony and streamline the hearing. Each of those witnesses will nevertheless start by briefly summarizing that testimony. In my experience, it doesn't end up being so brief, but it's intended to shortcut the process a little bit by having them pre-file the direct. But I like to start orally as well to give the board and the public some context rather than just jumping into cross-examination of the written pre-filed. So we'll start with direct examination by each expert witness. So far, Eastern has pre-filed the direct examination of Deborah Darby at Tetra Tech with certain exhibits. And the board has pre-filed the direct examination of Brian McCormick and Nicholas Ames, whom I see on the screen, with exhibits. My pre-hearing order also required parties to list their fact witnesses and proposed exhibits, not to pre-file any direct testimony, but to at least tell us who's going to be taking the stand. And Eastern has done so. And I believe that all documents regarding the hearing, everything that's been pre-filed, public comment, and everything else will be publicly available at the Health Department and on the website. Let me say a word about decorum. Not usually a problem, but it just bears keeping in mind. DP's regulations require that everyone shall conduct themselves in a manner so as not to obstruct or delay the orderly presentation of evidence and issues. And they authorize me to take all appropriate action to maintain that standard, which I intend to do. Please bear in mind how difficult and time-consuming it is for a volunteer board to make a decision like this, and keep your comments civil and focused on the relevant issues. The agenda for May 12th, Monday night, is that I will start by swearing all the witnesses. I'd like to swear everybody at the opening hearing so I don't forget to swear somebody later, but I don't require that they be there that night if they are not going to be testifying. But everybody who's testifying, and ideally all the experts, I will swear everyone at the beginning. I will describe any additional submissions I've received, who I decided may intervene and who may not. And then we will turn to Eastern's witnesses and begin the testimony. I'm hoping to get that preliminary stuff out of the way pretty quickly and dive into the testimony shortly after 7 o'clock. I don't know exactly how long it'll take. Those are my opening comments. What I want to do is two other things. One is to address a list of questions that the board has sent me, procedural questions, or that Ms. Hurley has on behalf of the board. And then I want to see if council thinks we can accomplish anything else tonight, or has any comments on anything I've said, or if the board does. But let me turn to the board's questions. I don't know that I can answer each of the questions and parts and subparts, but let me see if I can orient you a little more. When can the board speak? What's the protocol to ask to speak? During testimony, after testimony, most of your comments will probably come through your counsel, Peter Durning or Peter Buteri, if he's here of Barrow Law. But you can speak as well. I'm not going to interrupt testimony if I can help it. But at some point that makes sense, doesn't interrupt the flow too much, doesn't throw the witness off track too much. If you have a question, that's fine. And yes, it can be from each individual board member if you do have a question. Can the board express opinion to testimony or witness response during cross-examination, or is that done solely by counsel? If only by counsel, what's the process to communicate a line of inquiry or dispute during testimony or cross? Well, as to the second question, you're meeting with your counsel. You're conveying your concerns. Counsel should be preparing anticipated cross-examination before we get there, just as any lawyer would in any case in court. If something new comes up and you need to communicate with counsel, you can get up and go lean in his ear, or at a recess. We'll figure out some way to do it. This is not a very formal proceeding. It has some trappings of formality. People are under oath. I rule on things. Evidence has to be relevant. This is more formal than a zoning hearing or a conservation commission hearing that people may be used to. This is unique in local board hearings in my experience, but it's not overly formal. And as long as people are not prejudiced by something somebody else is trying to do, as long as it's not taking too much time, throwing us off track, I'm inclined to be lenient and make sure that the record is complete for the board. So I don't think you need to worry about undue formality unless something is late and prejudices the other side, something like that. Can the board express opinions of testimony or witness response during cross? I would say no, but not because it comes from counsel. I would be reluctant to see you forming opinions on part of the evidence. I wouldn't leap to conclusions. It's going to be a multi-night hearing, and it's possible that you'll hear something in rebuttal at the next hearing. So obviously you'll be forming opinions as you go, but I'm not sure I would like to see you express those opinions.
Mr. Krieger?
Yeah.
Mr. Krieger, I just want to clarify on that one. That question was more around if the board heard something that they perceived to be inaccurate or, not genuine. Are they allowed to speak up during that time frame?
If the board said something was inaccurate, they're essentially testifying contrary to what the witness just said, and the board is not here to testify. So I would say route that through counsel. Counsel can deal with that in cross-examination.
Thank you.
And then, of course, you can deal with it when you put on your own witnesses. And those witnesses can respond in their testimony to what they've heard from the previous witnesses. So there are several ways you can get your opinion out, but not by commenting on the witness directly. Can new testimony be added after pre-hearing submission by either party to respond to something that came up? This is part of what I said a moment ago. I'm not going to be a stickler for protocol as long as we're on a very tight timeline, which is burdensome on everybody. People trying to file their pre-filed direct examination, the board trying to meet and grapple with things and understand the process. The experts need to turn around their testimony pretty quickly and react to what they're hearing. It's not an easy process at best, and this is accelerated because of the DP regulations and the deadline. So the answer is, I'm going to be fairly lenient in new testimony coming in or new issues being raised, as long as, again, there's no prejudice to the other parties, as long as everybody has time to react to those and respond if they need to. Can other expert witnesses be added post deadline by anybody? Again, I'm trying to make this as orderly a process as possible. So I would hate it if 5 new experts came in and raised 6 new issues. But I'm not going to say no as a blanket rule. If something needs to be addressed and is relevant to the citing criteria, relevant to the board's decision, again, absent prejudice, I may be inclined to let it in. Obviously, I'm not guaranteeing my decision on any particular situation that may arise. But my general approach is, if you have something else you want to say, or that you need to say, or evidence you need to put on, and you didn't say it in time earlier, ask me. Just try, and of course show it to the other side and try to minimize the prejudice. When will commenters be allowed to speak in the general public? I think I addressed that earlier. All members of the general public will be allowed to speak, unless it's, again, subject to duplication and overall time limits. I don't know when it will come. It may be on the second night of the hearing, maybe on the third. It won't be on the first night of the hearing. And I'm not counting this as the first night. Monday is the first night of the hearing, really. Are there circumstances that allow us to extend the time frame for deliberation? I believe the answer to that is no. That's a legal issue. I think there's case law on it, and I will leave it to counsel to advise you whether you can have more time. My job is to just get the case to you as quickly as I can. But I think I'll leave it to Peter Durning and Peter Viteri to advise you whether there's any basis for an extension under the case law. Fees for technical and legal fees exceed the amount paid by applicant. When will I address that gap as the regulations allow? I don't know that that's anything I need to address at this stage, and I'm not sure that I address the gap. The board is authorized to request more payment by the applicant. So I'm not sure I will do anything about that one. The sequence of events across the hearing process, what can attendees expect? I think I've probably covered a lot of that in different respects, but in general, witnesses are going to take the stand, have direct testimony, have cross-examination. I don't know yet how many of the interveners, how many of those people who petitioned, or groups who petitioned, who become interveners. I don't know how many of them are going to have cross-examination. I don't know how many of them are going to have witnesses of their own. But we will go applicants, witnesses, and assuming I'm going issue by issue, I mean, there will be an overall introduction to the project. We're not going to dive into an issue. Eastern's going to put on a civil engineer or the owner of the company or somebody to describe the whole project. And he or she is subject to cross-examination like everybody else. But when we get into the experts, which are really the heart of the case, because they're going to address each citing criterion, Eastern will put its on. There will be crossed by whoever needs to cross, and then redirect, and then potentially recross. Exhibits will be admitted in evidence. I'll rule on any objections. And let's say, just as a random example, all of that had to do with traffic. I'd like, as I said, to finish all of traffic in one night so that it's all together for the board. Now, that it often happens that there's rebuttal. Somebody comes back at a hearing 10 days later and has done more traffic study or something. There can be a round of rebuttal. So it's not like all the traffic will necessarily be on one night or all the groundwater on one night, but I'm going to consolidate those topics as much as I can. But we're going to go witness by witness, direct, cross, et cetera. Again, the cross is by multiple parties potentially. Then we'll move to the next witness. The question was a general one. I hope that helps answer it. What role does the health department have as agent?
Mr. Krieger,
Yeah, sure.
Mr. Krieger, this is a really important part. I know a lot of people in the audience are also interested in this. So when you say section by section, will the applicant within the section present, and then the testimony from the board present? Will it be sort of both parties will present and then both parties will cross? And if you are a party deemed by your decision, will they also have the opportunity within a section to present testimony and cross any of the witnesses?
Yeah, sorry, I tried to cover that, but I may have been going too quickly. So I'm not sure that I'm going to go issue by issue, because there are, as I noted, 19 or something, 17 citing criteria. I don't want people jumping off and on and off the stand, multiple times. I assume that the experts at the beginning will cover all the citing criteria. But it has happened that on 2 or 3 of the major issues, I've gone issue by issue. I may not do it that way. I don't know enough about the case yet to decide that. But to answer your question, the applicant will put on its case, direct examination by Mr. Favaza, cross-examination by Mr. Durning or Mr. Viteri, and then cross-examination by any other intervener, anybody else whom I have allowed to intervene. It could be all 6 of them. It could be that I've only allowed 3 of them to intervene and not 6. It could be that I allowed all 6, but only 3 of them have an interest in cross-examining, or that they've put their heads together and they have one consolidated cross-examination. I have no idea how that's going to play out, and all I know is what's presented to me. But everybody will have an opportunity to cross-examine each witness, no matter who put that witness on. Everybody who's a party, everybody whom I allowed to intervene, plus the parties being Eastern and Manchester by the Sea Health Department or Board of Health. Does that answer your question, Dominique?
Yes, and I don't believe, unless it was when I was hunting for Joel's phone number and contact information, did you also help the interveners and parties understand what the criteria are that you're going to use to decide whether they can or cannot become a party?
I'm sorry, you're asking me to do that now?
Yes, if you haven't, I think it's also, I think if folks in the room would probably like to understand that as well.
Okay, give me a second. So I'm going to paraphrase 16.20, 310 CMR 16.29 A and B. These regulations are not very clear, and there are sort of overlapping standards for who gets to intervene. They say the following: persons whom I determine are specifically and substantively affected by the hearing, meaning really by the project, shall be allowed to intervene. So anybody who's specifically and substantively affected shall be allowed to intervene. So an individual, as opposed to 10 citizens, I'll get to them in a minute, but an individual who lives across town may have a tough time meeting that standard. They have to tell me why they would be specifically and substantively affected by anything, by the traffic of the facility, by the noise of the facility, the odor, whatever they're concerned about. Any abutter or group of abutters to the proposed facility shall be a party. So abutters get to come in, or groups of abutters. Any group of 10 or more persons, so not necessarily abutters, may register collectively as a party. And I mentioned there are 3 10-citizen groups, one represented by council and two not. The intervention shall be limited to the issues of impacts to public health, safety, and damage to the environment. In other words, interveners, at least 10 or more persons, but maybe any interveners, can't complain that this is going to cost the town money or have some social impact that goes beyond health, safety, and damage to the environment. All of the citing criteria deal with health, safety, and damage to the environment, and the intervention should stick to that as well. They have to submit the petition to intervene before the commencement of the hearing, and the 6 people that I named obviously have done so. And that's really all it says on that. So let me see if I can summarize that, because as I said, the regulations are not real clear. And a abutter gets to intervene. And by the way, this is my reading of the regulations. Counsel for anybody can take a different view and make the argument to me if they want, if they need to. But my reading is that an abutter gets to intervene. Any group of 10 or more people, persons can intervene on the issues of health, safety, and damage to the environment. And that's really my guidance. The regulations have a second category besides intervener called participant. And every petition to intervene is also deemed to be a request to participate. They still have to be, participants have to be specifically affected, or anybody who is specifically affected shall be permitted to participate. The difference is an intervener is a full party. They can cross-examine, etc. A participant is limited to the right to present testimony, to argue orally at the end of the hearing, and to file a brief. But they don't get to cross-examine. Nor are participants required to submit to cross-examination unless I decide that they should be.
Okay, wonderful. And in case somebody has, you know, tried to meet the deadline, written a document very quickly, and they're missing something that you might require to enable them to be an intervener, will you reach out to them, or will you let me know that you're missing information so that I can follow up with that party, or how will that work?
I'm not going to reach out to them. That wouldn't. I don't think that would be appropriate for me to be having side conversations with potential interveners to whom the applicant might object, for example. No, I think I'm just going to take what they file, see if there's any objection. If there's no objection, then even if it's marginal, unless they're missing key things like the names of the 10 people, I'm going to be inclined to let it in. If there's an objection, I'll have to make a ruling. But I can be talking to you about whether the petition looks complete, but there's not a lot of time for me to do that. And so I'm not promising to. I will wait Friday at 5 o'clock. I'll see whether there are objections to anybody. If not, it makes my life a lot easier. If there are, I will rule over the weekend so that those people can file their pre-filed testimony, and for any experts, if they have them, as I mentioned earlier.
And then will you be letting us know who is or isn't an intervener? Because of course, then if they have testimony, there's a filing deadline for Monday. And
that's
so
right. That's why I'm committing to try to decide over the weekend, or really by Saturday. So the answer is I will make a decision on all 6 with or without objections, and email you and council, and then you can contact those people, or they should be alert to checking the website over the weekend. If you'll be able to post things on the website as I decide. I'm not going to issue written decisions that fast. I'm just going to make a decision, yes or no, on each of them after I look at any objections and look at the criteria again, and I'll decide as quickly as I can. But I'll let you know, and then I'm going to leave it to you to let them know by the website or by direct contact. I'm putting a lot on you, Ms. Hurley, but I don't have a lot of choice in this timeline.
I'm happy to help. I just wanted to be sure I was clear on that, so I could keep communication going well.
Yep. So anybody who's positioned to intervene, those 6 should be checking the website or checking their emails, because you might just email or okay. Was somebody trying to say something?
Art, if I may, this is Peter Durning. Just Dominique, I can assist you with that process. I assume that most submissions did provide a contact email for the intervener process. So I think we should be able to reach out to notify those people once we hear from Art, and I can assist you with that.
Thank you.
Okay, the last set of questions from the board was what role does the health department have as agent of the board in these deliberations? By deliberations, I assume you meant in the hearing rather than when the board is deciding after the hearing closes. Yes. It says can they, but I trust it means you. Can you, Ms. Hurley, ask questions or submit testimony? I guess if you've been properly identified or made the proper submissions, and Mr. Durning wants to put you on the stand, I suppose that's acceptable. I'd have to think about it. If there's an objection to it, I would have to think a little harder about that. You can certainly ask questions through counsel. But if you have an important question and need to ask it yourself, I might allow that. Again, it's a matter of interrupting the flow of things. I don't want, too much free flowing back and forth cross current conversations. But if you have a question, you'll be able to ask it directly with your counsel.
Mhm.
Thank you. It's mostly be procedural, and you gave me a good example of something that you expected me of, like, filing documents and being sure that we stay current on all of that. So it's more that I'm looking for, and again, any role that I need to carry during the process.
If anybody has a procedural question, sure. I mean, if it can't wait, I mean, if it can wait till a break, just run it by me. But otherwise, yeah, if it's affecting what we're doing at the moment, then sure, you can ask it. So board 7 to 10, I know is a long meeting for you. We'll take breaks in the middle. I'm afraid of taking a break every hour because breaks tend to stretch and we'll lose a lot of time. If it sounds okay to you, we'll take a break at roughly 8:30, halfway through. But that's really your call, because I don't want to overtax you, and I want you able to pay attention. So if that sounds okay, that's fine. If you'd like to do something different, we will. All right, that's all my comments, and I've asked all the questions that were given to me. Does anyone else have any other questions or want to make any other comments?
Mr. Krieger, if I could make a comment that I think would be helpful to the public to hear.
Can you just identify yourself, please? I can't tell who's who there.
Sorry, this is Joe Rosa, the chair of the board.
Good evening.
So consistent with your preamble at the beginning of this session, the evaluation that the board has done, as well as their technical associates at Weston and Sampson, have used the state regulations and laws regarding the suitability criteria. They have not used any local regulations that are appropriate to Gloucester. That, I'm told, can occur later on in the process should this initial hurdle be overcome. So I just wanted the public to know that Gloucester has certain regulations of its own that are appropriate to our geology and geography. Those have not been applied at this point. They will be applied as requests become before it regarding the construction of the facility.
So, okay, so they will be applied in a future decision, not in the site assignment decision, is what you're saying.
Correct.
Yeah, I think that's right. The site assignment decision, I believe, is limited to the site assignment criteria, DEP's regulations that I mentioned earlier, under 16.40. What happens in a future proceeding is really not my place to say anything about, and it's not my business. But you've said your piece for the benefit of the public, and that's fine. If you were to try to introduce local regulations here, and there were an objection, I'd have to make a decision about that. But it doesn't sound like you're intending to do that.
Correct.
Art, if I may, I'll just speak on that as well.
Sure.
So this is Peter Durning. I'm counsel to the Board of Health. I just want to amplify Chair Rosa's comment and maybe provide a little bit more context. For example, this site assignment hearing is but one administrative process with respect to the construction of this facility. There may be other administrative proceedings, such as before a conservation commission or applying for a building permit. And those subsequent proceedings will proceed according to state and local regulations. But what is before this board is really just the sole question of whether this land shall be site assigned. And as the hearing officer has appropriately described, that is based on the very specific categories of siting criteria in 310 CMR 16, section 40. And so that is really the focus of this site assignment proceeding. Thank you.
Correct. Does anybody else council, authorized representatives of the 10 citizen groups, or anybody else have anything they'd like to say?
Yeah, I'd like to just ask Mr. Krieger, the requirement that witnesses be in person in the auditorium. I'm curious as to the reasoning behind that. If we are using this as a hybrid meeting, and if witnesses could otherwise be on camera and subject to cross via Zoom, why they must be present inside the auditorium to testify.
Because it's much easier to evaluate a witness's testimony in person. I mean, this is not the kind of case that's going to turn on credibility in terms of somebody lying. I'm not suggesting that, but still testing their expert opinions. It's good to see a witness in person to know how confident they are in their opinions, to be able to make judgments about the testimony. You get a much better read on a person, on any witness, in person. I don't know that any court allows witnesses to testify on Zoom. I haven't seen that. Maybe you have.
Certainly not since COVID ended for a trial. But again, as you mentioned, this is, more formal than you might see at a zoning board, but still a fairly informal process. And so to the degree that, witness may not be local, especially whereas this hearing could go on for multiple nights, be very difficult to ask, an engineer from New York to come up for the 12th, maybe the 15th, maybe a different date. Whereas if they were allowed to present, via Zoom, again, I would stipulate to things like on camera, the entire time, that sort of thing. That would just make things pragmatically a lot easier than requiring them to be on notice, to be physically in Kyra's auditorium in Gloucester, for a maybe.
Well, I certainly am sympathetic to that. And if I were counsel, I wouldn't want to have to pay the witness for multiple trips that could be wasted either. So one answer is I am going to try and give people as much notice and make sure they get on the stand when they're there, especially if they've come from out of town. I mean, that would be one purpose of going issue by issue, is if you're a traffic engineer, you know what night you're going to be there, and you don't have to come back to hear the other side's testimony. It's going to be the same night as yours. So I'm going to try and consolidate things and make things as orderly as possible for the issue that you're talking about, in addition to other reasons that I've mentioned. If someone has a real problem showing up in person on a particular night, or if they have long-standing plans that can't be disturbed, then again, just ask me, and we'll see how the other side, the other parties and council feel about it. If there's no prejudice, if the board is okay with it, then that's fine. I'm not going to insist on that formality for the sake of formality. It's a functional test of what makes the most effective testimony and most effective record building. So I'll try and deal with it as we go, Joel. But my starting point is that if you're going to testify, you should be there.
So thank you.
Anyone else? Again, I can only see a fraction of the people who are apparently participating in this call, so I have no idea who's out there or whether any hands are raised.
Do you want me to open this to the audience? Some of the intervener petitions are here, and commenters.
Yeah. No, let's start with the people who petitioned to intervene. And yeah, let's see if they have any comments on any of this.
So does any intervener have a question for Mr. Krieger? And if you do, if you could come up and use that microphone over there and say your name and address and what party you're part of. I don't see anybody. I got crickets here, so nope, no interveners, it looks like, want to step up. You want me to?
Okay. I happen to like crickets, and I'm really sorry that that's become the shorthand for a bad result. I think crickets are great, but I take your point that nobody wants to speak. How about members of the public? Anybody else, Dominique?
Anybody else, a commenter or other member of the public want to speak? And let me just look online as well, one moment.
Sure.
Great.
If you're online, if you could please raise your hand so I can see that you want to speak. There are no hands raised for those online.
Okay. People can ask questions at subsequent hearings. This was not their only chance to do so, but, and as I said, they'll be permitted to comment later, but I'm glad that there are not a lot of burning questions tonight. I take it everybody's feeling somewhat comfortable with the process so far. So we will reconvene on Monday at 7. Dominique, as I said, I'm going to be up there early, partly because I might as well beat rush hour. But I want to have time to sit with the documents with you. So I'll probably get up there mid-afternoon on Monday and then stay through the hearing.
Fantastic.
And I think that's probably all we can do for this evening, which was a fair amount of procedural stuff.
Yeah, Art, if I may, this is Peter Durning again from Vero Law on behalf of the board. I just want to thank you for convening the hearing tonight and getting through these procedural steps. I think it'll be effective and efficient to then start on Monday. So I appreciate you taking the time.
Okay. My pleasure. Thank you all for participating or at least attending this call. Members of the board, thanks for embarking on this process, and Ms. Hurley, thanks to you for your help so far. That's all I've got for this evening then. So I will continue this hearing to Monday at 7 o'clock in the Kairos Auditorium. And we'll see everybody then.
Excellent. Thank you.
Okay.
Thank you.
Thank you.